We have major legal developments tonight, and they look like this, and I'm going to walk you right through them. These are two separate cases where two judges have ruled for major Epstein transparency and basically changed what is longstanding precedent on what materials you release from criminal probes. I'm going to walk you through it here in plain English. The big development today is one of these cases, a judge granting a motion to release sensitive Epstein records, specifically to unseal what are grand jury records in the Ghislaine Maxwell case. Now, that mirrors another ruling, and I'll tell you about that as well. But if this sounds like a huge change, it is. If you think back to every case you've ever looked into, maybe you're a true crime Whitey Bulger fan, maybe you remember the Mueller probe, grand jury materials are protected by Rule 6, which is one of those sort of long-standing rules of the federal court system. And the reason the grand jury materials are usually secret is because, unlike, say, an open trial where the government is presenting certain evidence, this is a private process designed to decide whether you get to trial or not. And for many reasons of fairness, say they don't indict and move forward, you don't just release everything they ever talked about. It could affect people's lives or careers. That's generally the baseline. But there is a new law in town. It's called the Epstein Files Transparency Act. You probably recall it because it was passed over the objections of Donald Trump all year. Then at the end, he claimed he was for it. He was forced into signing it. Republicans bucked him. And that law now requires the release of a ton of different types of Epstein material, colloquially referred to as the Epstein Files, this month by December 19th. So this new ruling responds to that law, and it comes just after another judge agreed in another case that also involves Epstein in Florida. Remember, there was that earlier Epstein case down there?
All right, we need to talk about something major that's happening right now with the Epstein files, because what we're witnessing is genuinely unprecedented in how our legal system handles sensitive criminal records. Two separate judges have just made rulings that are fundamentally changing decades of legal precedent about what gets released from criminal investigations. And I'm going to break this down for you in plain English because this is bigger than most people realize, and the implications go way beyond just this one case. Here's what happened today. A judge granted a motion to release sensitive Epstein records, specifically ordering the unsealing of grand jury materials from the Ghislaine Maxwell case. Now, if you're not a legal expert, you might be thinking, okay, they're releasing some files, what's the big deal? Let me explain why this is absolutely massive. Grand jury materials are sacred in the American legal system. They're protected by something called Rule 6, which is one of those long-standing foundational rules of our federal court system that lawyers and judges treat with almost religious reverence. By the way, I am trying to do my best to gather all the information I can for you and share it with you. Please leave your likes and comments, and I would be grateful if you subscribed. Let's continue. The reason grand jury proceedings are kept secret goes back to fundamental principles of fairness and justice. Unlike a public trial where the government presents certain evidence in open court and everything is transparent, a grand jury is a private process designed to determine whether there's enough evidence to move forward with charges. It's where prosecutors present their case to a panel of citizens who decide if someone should be indicted and face trial. And here's the crucial part. If the grand jury decides not to indict, if they determine the evidence isn't strong enough to proceed, you don't just release everything that was discussed in those secret proceedings. That would be fundamentally unfair to people who were investigated but never charged. Think about it this way. Maybe someone's name came up during an investigation. Maybe they were tangentially connected to something. Maybe prosecutors presented information about them to the grand jury, but ultimately no charges were filed because the evidence wasn't there, or they weren't actually involved in wrongdoing. If you then release all those grand jury materials, you're potentially destroying someone's life or career based on unproven allegations that never resulted in charges. That's why the default position for literally every criminal case you've ever heard about, whether it's Whitey Bulger, the Mueller investigation, any major prosecution, grand jury materials stay sealed. It's been that way for generations. Until now. Because there's a new law in town, and it's called the Epstein Files Transparency Act. You probably remember this legislation because it became this massive political story throughout the year. Donald Trump objected to it. He fought against it. He clearly didn't want this law to pass. And then at the very end, when it became clear that Republicans in Congress were going to buck him and pass it anyway, he suddenly claimed he was for it all along and signed it. But make no mistake, he was forced into signing this law by his own party members who refused to let him kill it. This new law requires the release of a huge amount of different types of Epstein-related materials, what people have been calling the Epstein files. And the deadline is coming up fast, December 19th of this month. So this new judicial ruling is responding directly to that law, and it comes right after another judge made a similar decision in a different Epstein case down in Florida. Remember, there was that earlier Epstein case in Florida before the more recent federal prosecution. A Florida judge has ordered those Epstein grand jury records to also be released using the exact same legal logic. Now, this might sound like we're getting deep into legal minutiae that only lawyers care about, but I want to highlight a few crucial points that make this incredibly significant. First, this demonstrates why Congress, why our legislative branch, still has enormous power even when it seems like they're not doing much or they're just fighting with each other all the time. Because of the sustained push that we followed throughout the year, survivors of Epstein's abuse, Republican Congressman Thomas Massie, and others who championed this cause, they actually won. They overcame objections from the House Speaker, they overcame Trump's resistance, and they passed this transformative new law. The lesson here is that new laws can change everything. Judges who literally last month were saying, hey, we can't release grand jury materials, they're always secret. That's just how our system works. Those same judges today are reading the new statute and saying, well, there's this new law and it explicitly says release everything, and this applies to all these materials. The law changed the game completely. That's the power of legislation when it's done right, when there's genuine political will behind it. Second point, and this is where things get really interesting. We've heard a lot of speculation and concern about whether the Trump Justice Department would try to play games with these files, whether they'd find ways to hold back materials or heavily redact documents or drag their feet until everyone forgets about it. But here's something that might surprise you, and maybe people who think everything Trump does is wrong will have to sit with some cognitive dissonance for a moment. These rulings ordering the release of materials are coming because the Trump DOJ asked for them to be released. Read that again. This is not happening because some advocacy group filed a lawsuit. This is not happening because a survivor's class action forced the government's hand through litigation. This is Pam Bondi's Justice Department. Under pressure, of course, but the pressure worked. They're the ones who went to these judges and asked them to allow the release of the grand jury materials under the new law. Both of these judicial rulings that will release new Epstein and Maxwell files from previously secret grand jury materials are happening because the DOJ was pushed into requesting it, and they actually did. Now, does that mean we should just trust everything the Trump administration does from here on out? Absolutely not. Does it mean they're doing this out of the goodness of their hearts? Of course not. They're doing it because the law requires it, and because the political pressure, particularly from Trump's own base, who care deeply about this issue, made it impossible for them to stonewall. But the fact remains that rather than fighting these releases or trying to delay them indefinitely, the DOJ invoked the new law and asked the judges to permit the disclosures. That's actually significant. And here's the third point, which is crucial for what happens next. Everyone is watching to see if they play games as we approach that December 19th deadline. But what we have now are new rulings from federal judges saying, no, you have to release this material because the new law requires it. So if Pam Bondi or anyone else at the Justice Department later tries to heavily redact everything or claim they can't release certain documents, they're going to run face first into these judicial rulings that explicitly say the law mandates transparency. That makes it much harder for anyone to hide too much going forward. The legal framework has been established. The precedent is set. Playing games now would put them in direct violation of court orders. However, and this is important, one of the judges did criticize Bondi's DOJ in their ruling. The judge said that while the Justice Department paid lip service to the victims of Maxwell and Epstein, they have not treated those victims with the solicitude they deserve. Now, that's a separate point from the transparency issue I've been discussing. That criticism refers to many past problems in how the Justice Department has handled victim relations and victim support throughout the various Epstein prosecutions. The judge is basically saying the DOJ has failed the victims under Trump's administration, which is a damning assessment from someone on the bench reviewing their conduct. Meanwhile, the House Oversight Committee has been releasing new images and videos from Epstein's island. They're saying more material is coming, including what they describe as important bank records. This is all part of the broader effort to finally get full transparency about Epstein's activities, his network, and everyone involved. Donald Trump has discovered this is an issue he cannot spin his way out of and cannot outrun. His base, the people who support him, remain intensely interested in whether he complies with this law that they know he was forced to sign against his will. And this brings us to one of the most fascinating aspects of this whole story: the role of Marjorie Taylor Greene. MTG sparred with Trump over the Epstein files and ultimately over other issues as well, leading to her resignation from her position. But in her recent 60-minute interview, she made some pretty explosive remarks about her back and forth with Trump regarding the Epstein files. She revealed that they did talk about the Epstein files legislation, and according to her, Trump was extremely angry at her for signing the discharge petition that helped force the bill forward. Trump told her, according to MTG, that releasing the files was going to hurt people. When she pushed back and pointed out that the women who were Epstein's victims are the ones who were hurt, Trump responded by saying, "People will get hurt." MTG says she doesn't know what that means. She doesn't know who Trump was referring to, but she's essentially calling out what she implies was Trump either grandstanding or making some kind of veiled threat. And she makes a really good point. If Trump genuinely believed people would be hurt by these releases and he genuinely cared about protecting them, he could have vetoed the bill. He could have fought it to the bitter end. Instead, he seemed to go with the political wins once he realized he'd lost the battle. That exchange between Trump and MTG is revealing on multiple levels. First, it shows Trump was actively trying to prevent these releases behind the scenes, even as he publicly claimed to support transparency. Second, his argument that people will get hurt is interesting. Who is he worried about? If the concern is protecting victims, well, the victims and their advocates are the ones pushing for transparency. They want these files released. So who else would be hurt by the truth coming out? The implication, whether Trump intended it or not, is that powerful people connected to Epstein would be exposed and damaged by full disclosure, and Trump's resistance to that disclosure raises obvious questions about his own connections to Epstein and what might be in those files. Now, everything I'm telling you is about how these legal cases are working and how, so far at least, the pressure is working on the Trump DOJ to deliver more Epstein transparency. But here's what we don't know, and it's important to be honest about this. What's actually in the grand jury materials? Nobody knows. They're secret. That's the whole point of grand jury secrecy. And I've seen some folks online, podcasters maybe, people who aren't formal journalists or lawyers, making claims about what's in these files or promising that there's going to be huge explosive revelations. But the truth is they don't know either. You should always be a little wary of people promising you specific details about something they haven't read or seen. It's easy to build hype and make dramatic predictions about sealed documents because nobody can fact-check you until the documents are actually released. And by that point, if your predictions were wrong, you just move on to the next thing and hope nobody remembers. So I'm not going to sit here and tell you that these grand jury materials contain this or that bombshell. I don't know. You don't know. The podcasters making promises don't know. We'll find out when they're released. Interestingly, and this is worth noting, one of the judges actually tamped down expectations in their ruling. The judge stated that the grand jury materials would not reveal new information of any consequence. That's a striking statement. Now, whether that assessment is accurate for both cases, why the judge believes that, whether everyone will agree with that characterization once we actually see the materials, all of that remains to be seen. But it's notable that a judge who has presumably reviewed or has knowledge of what's in these files is telling us not to expect earth-shattering new revelations. That could mean a few different things. It could mean that most of the really damaging information about Epstein and his network has already been made public through previous court proceedings and investigations. It could mean that the grand jury materials are largely duplicative of what we already know. It could mean that the most sensitive information was presented through other channels that aren't subject to these transparency requirements. Or it could mean that the judge's assessment of what constitutes information of consequence differs from what the public might find significant. But the deadline is coming. December 19th is right around the corner. And regardless of whether these specific grand jury materials contain blockbuster new information or not, the principle that's been established here is huge. For the first time in modern legal history, we're seeing grand jury secrecy rules being overridden by explicit statutory requirements for transparency in a high-profile criminal case. That precedent could have implications far beyond just Epstein. Think about what this could mean for future cases involving powerful people, corruption, organized crime, whatever. If Congress decides that public interest in transparency outweighs the traditional protections of grand jury secrecy, they can pass a law similar to the Epstein Files Transparency Act and force disclosure. That's a new tool in the accountability toolbox. It's not something that should be used lightly or frequently, because there are legitimate reasons for grand jury secrecy. But in cases where there's overwhelming public interest and concerns about cover-ups or protection of the powerful, this precedent shows that transparency can be mandated. The Epstein case specifically has always raised these concerns because of the sweetheart plea deal he got in Florida, because of the apparent preferential treatment he received for years, because of the long list of powerful people who were connected to him in various ways. People have suspected for years that the full truth about Epstein's activities and his network has been suppressed to protect influential figures in politics, business, entertainment, and other spheres. Whether that suspicion is justified, we're about to find out to some degree. The House Oversight Committee's release of images and videos from Epstein's island is part of the same transparency push. Those materials apparently show the scale of the operation Epstein was running, the infrastructure he had in place, and the committee is promising more, including bank records that could potentially trace money flows and reveal who was funding what. Financial records are often more revealing than anything else because money leaves a trail that's hard to obscure completely. What's interesting about Trump's position throughout all of this is how it's evolved. Initially, when he was still pretending to be friendly with Epstein years ago, he made comments about Epstein liking younger women and knowing him socially. Then, as Epstein became toxic, Trump tried to distance himself, claiming they had a falling out years earlier. When the calls for transparency about Epstein's network intensified, Trump resisted behind the scenes while trying to maintain plausible deniability publicly. And now that the law has passed and he couldn't stop it, he's attempting to claim credit, or at least avoid blame. But his private comments to MTG reveal his actual position. He didn't want these files released. He fought against it. He warned that people would get hurt. And when pressed on who those people are and why protecting them should take priority over justice for victims, he apparently had no good answer. That's telling. That suggests Trump's concerns were not about protecting innocent people from unfair allegations, but about protecting connected people from exposure. The victims and survivors of Epstein's abuse have been clear about what they want: full transparency, complete disclosure, accountability for everyone involved. They've had to fight for years just to get basic information about what happened to them and who was involved. The justice system failed them repeatedly, from the original sweetheart plea deal to the way subsequent investigations were handled. So when they finally get a law passed that mandates transparency, and Trump opposes it, that tells you whose interests Trump was prioritizing. And it wasn't the victims. The fact that Pam Bondi's Justice Department is now complying with the law, at least so far, shows that the pressure campaign worked. Public attention, congressional action, survivor advocacy, all of it combined to create a situation where even an administration that clearly would prefer to keep these files sealed has to move forward with disclosure. That's how accountability is supposed to work in a democracy. Citizens and their elected representatives demand transparency, pass laws requiring it, and force compliance even from resistant executive branch officials. But we're not at the finish line yet. December 19th is when materials are supposed to be released. We need to watch carefully to see what actually comes out, how much is redacted, whether everything required by the law gets disclosed, and whether the Justice Department tries any last-minute maneuvers to limit what becomes public. The judicial rulings we're discussing today make it harder for them to play games, but that doesn't mean they won't try. And beyond just this immediate deadline, there's a broader question about accountability. Even with full transparency, even if we get every document and every name, will there actually be consequences for people who were involved in Epstein's activities? Will anyone powerful face prosecution, or will we get disclosure without accountability, where we learn the truth but nothing really changes because the people involved are too connected or too rich or too influential to face real consequences? That's been the frustrating pattern with so many scandals involving the elite. We get investigations, we get reports, sometimes we even get admissions, but the actual accountability part, the part where people face serious legal or professional consequences, that often doesn't materialize. The system protects the powerful. That's not a conspiracy theory, it's just an observable fact about how American institutions have operated for decades. The Epstein case is a test of whether that dynamic can be broken, the level of public attention and outrage, the bipartisan nature of the transparency push, the involvement of victims and advocates who refuse to be silenced. All of that creates pressure that's hard to ignore. But pressure and accountability are not the same thing. We've seen plenty of cases where there was immense pressure for justice, and it still didn't happen because the people involved had enough power to avoid consequences. So as we approach December 19th, as these grand jury materials and other Epstein files get released, we need to pay attention not just to what's disclosed, but to what happens afterward. Do prosecutors act on any new information that emerges? Do people lose their positions or their reputations or their freedom based on what's revealed? Or do we get a brief news cycle of shocking headlines followed by everyone moving on while the powerful people implicated continue their lives largely unaffected? The judges ruling on these transparency questions have done their part. They've interpreted the new law, they've ordered disclosure, they've rejected arguments for continued secrecy. Congress did its part by passing the Epstein Files Transparency Act over Trump's objections. Survivors and advocates have done their part by keeping pressure on and refusing to let this issue fade. Now it's on the Justice Department to fully comply, on journalists to thoroughly investigate and report on what's released, and on the public to demand accountability for whatever is revealed. This is one of those moments where we find out if our system can actually deliver justice when powerful interests are involved, or if transparency is just theater that makes us feel like something is happening while nothing fundamental changes. I want to believe the former. I want to believe that this time will be different, that the combination of legal requirements, public pressure, and judicial oversight will force real accountability. But I'm also realistic about how these things usually go. What I can tell you with certainty is that the legal framework for disclosure is now in place, the deadline is coming, and the Trump administration, despite clear reluctance, appears to be moving toward compliance. That's progress. Whether it's enough progress, whether it leads to actual justice, that remains to be seen. But the wheels are turning, the clock is ticking, and December 19th is almost here. We're about to find out what's been hidden in those grand jury files for all these years, and what our institutions do with that information once it's public.